Good morning, friends. And today we are starting another webinar point, and today's topic is insight into the merger amalgamation. Welcome to the webinar of Saturday Knowledge or Saturday Knowledge 7 webinar. Today's topic is insight into the merger and amalgamation. And today our panelist is Ms. Mukti Shah, Senior Manager Hathway. Welcome, Mukti. Thanks a lot for your time.
Thank you so much, Aditi ma'am. Thank you so much. I'm so sorry I'm yet not able to.
No issue, no issue. Ms. Mukti is a qualified company secretary and LLB with more than 8 years of experience in corporate and securities law. She co-manages the secretarial function at a Reliance Group company, where she oversees compliance and governance for Hathway and its group entities. Before this, she was CS of Purple.com and Crossword Bookstores, as well as Assistant Company Secretary at Shopperstop. Earlier in her career, she served as a manager, corporate secretary at Marico. Her core expertise encompasses corporate law, including Companies Act, SEBI LODR, SEBI PATE, SEBI ESOP regulation, along related governance framework. She has successfully led and managed significant projects such as right issues, strategic acquisitions, fast-track mergers, implementation of insider training norms, secretarial due diligence, major funding, compounding under RBI regulation. She has a history of seamless regulatory compliance and strategic alignment of corporate governance initiative with the overreaching business objectives. Welcome, Ms. Mukti. Thanks a lot for your time. Today's our presenter is Mr. Dvip Joshi. Mr. Dvip is a legal professional with over 10 years of experience in corporate legal advisory. He currently holds position as head legal consultant at Mehta and Mehta. He possesses extensive experience in managing intricate mergers and amalgamation, navigating insolvency matters under IBC, and addressing wide spectrum of company law issues. His specialization lies in non-litigation corporate advisory. He provides strategic counseling for the reconstruction of the company, delivers expert legal opinions, and drafts critical commercial contracts and agreements for diverse corporate clients. Of course, I need not introduce Mr. Bala. He is known to everyone. So today's moderator, welcome, Mr. Bala. So just to brief on today's topic, merger and amalgamation. As everyone knows merger, amalgamation, and people keeps on talking as and when. Everyone wants the exposure in that. As I learned and navigated this topic more and more, what I feel it's a mixture of a lot of legal compliance and procedural compliance. So I can say that after IPO, this is another second important big exercise, whereby two corporates, or I'll say more than two corporates, located either in the same state or different country, get merged. It's a big event. It's not like that two entered, because two different entity or more than two different entity. And it can be different business, it can be similar business and all that. So if you look at that at a business angle also, it's required a lot of planning and understanding, because your business is going to be merged. As regards other departments like compliance, accounts, finance, HR, admin, legal, this all will be one entity. So what will be the implications after your merger? That should be understood well in advance by both the organization. That should be synchronization. That should be understanding that what they want after this merger. It should not be just we thought and it happened. Many times it is for tax planning. Fine. If you are doing for tax planning, but the implications is same, because the company's business need to be merged, company's books to be merged, company's legal issues to be merged, company's HR, admin, employees, and registrations and various properties if it is, liabilities, everything required, and even the registrations. It's a big exercise. So before you decide that, this all should be kept in mind. It's not just accounts, but it is merging of entities. So it requires a lot of planning. One has to really go through the balance sheet and see the assets, where it is located at a different place. What is their value? And also the creditors, because you require creditors' consent. Assure that there is no issue in future. All this planning is required in advance because assets location has a stamp duty implication, their valuation. Creditor consent, if issue, you are half the way have problem. If your asset is not properly traced, it is issued. If your companies are at a different place, then you require two authorities or three authorities at different place to be attended, which is a momentous task. It's not easy. One authority will approve, another authority will not approve. So it is that all you have to keep in mind, that you will require that much infrastructure, time, and cost. And that's why it is required that you plan in advance. What is appointed date? What is effective date? I request when you plan this, you have to be little conservative, because there are more than one government authorities and your shareholders, your creditors, other authorities are involved. If it is listed, then stock exchange come into picture. If you are sector specific, your sector specific authority come into picture. So it's a big task and planning and strategy. And that's why actually lawyers comes when everything is finalized. And they have to, when you say draft the scheme, you have to write what you have decided. So this is the decision making by the organization. You can take the advice, but it is in principle your decision. You can take the advice of the consultant. What will be tax implication? What is in account impact? What I can do this account impact? What in legal I have help if this I will do actually. But in principle, you have to take all these important decisions and then you take advice. So this should be well prepared in advance. And lawyer, you have to tell that boss, we have decided this story. Now you write it so that court approves the same. And in this, I want to do this for this purpose. So that the consultant will advise, no, this cannot be happen, better you structure this way, that is fine. And this way it should be carried out. Post merger order also, there are so many things because you have to give impact. You have thought and planned that I want this. You have made application for that. You got the order, but now you have to work out implementation in such a way that you get the result what you plan. Your scheme should minutely cover everything. So you should tell lawyer everything. If you miss anything, again, you need to go for correction of the system, which our presenter, Mr. Dweeb, will share what we as a firm has experience of various ways, which will help all the participants. With this, I will request Ms. Mukti to say a few words on the topic, and then Mr. Bala, and then you can start the presentation. Thanks, everyone. Friends, this is going to be really interesting webinar because we are going to talk all practicals. Thanks.
Thank you so much, Deepti ma'am. I hope I am visible to all now. Good morning, first of all. Thank you so much for the introduction, Deepti ma'am, and I'm really thankful to Mehta and Mehta team and Bala sir as well for arranging this webinar and for arranging such frequent webinars, which really helps the fraternity, the professional, and as well as the students even to get insight into so much such sort of practical aspects of such matters which are not really discussed practically at all forums. So thank you so much for that. And a very good morning to all the participants who are here, who have spent their Saturday morning to attend this webinar. So thank you so much for that. Coming to the today's topic, which is merger and amalgamation. So to begin with, I think it is one of the crucial corporate strategies that enable companies to plan the growth, expansion, and to even think of synergies. So merger and amalgamation is definitely one of the crucial strategies that can be used by all sorts of corporates. Even if we look back in the history where the M&A had emanated from, so M&A really evolved in the Old Companies Act 1956, which got a lot of more clarity with the New Companies Act 2013, which streamlined a lot of processes with respect to the merger and amalgamation. So and even SEBI, I mean SEBI's role has also grew with the listed entities, being taken care of by SEBI and becoming stricter day by day for the listed entity norms, including the takeover codes and ICDR regulations. So SEBI's role also has grown to an extent where it has become very minute, even to get into the system, understand the process, and then even think of a process like merger and amalgamation. So it's not really a sort of just a checklist sort of a work that this has written in the section, this has written in the regulation, just follow the steps and you are done. So that's not at all a practical thing as on date. Even if we look at the legal framework, the Companies Act section 230 to 240 are the major section which covers and even definitely the rules which covers the nitty-gritties around the merger and amalgamations, including so many aspects surroundings like power of tribunals, cross-border mergers, minority shareholder related purchases, in fact, fast-track mergers. So there are so many topics which have been given under Companies Act, whereby the approval of shareholder, creditors, authorities like NCLT, ROC, RD, official liquidator has to be taken on a case-to-case basis, of course, depending on what type of merger you have been interpreting. Then considering I think there is one more interesting introduction by the Companies Act in 2016, which is a fast track merger, which was introduced by the law, whereby it also gained a lot of popularity because it helps the smaller sort of a companies and a company's merger between holding company and subsidiary company, with a simplified processes to get the mergers done for those sort of entities. Apart from the Companies Act, SEBI again also comes into picture when the listed entity is involved in the merger and amalgamation, where SEBI takes care of matters like fair pricing, transparency, and the shareholders' right to ensure that shareholders' rights are not really, affected when the change in control happens because of the merger and amalgamation. So this is where SEBI also comes into picture. So just like any other corporate action, I think there are a lot of advantages and challenges that comes along with any sort of a corporate action. And in merger and amalgamation also, there are some sort of challenges which a companies have to face, including some advantages. So to focus on challenges, so more of a practical challenges, to just name a few of them, the challenges would be related to regulatory approval, especially, definitely. Although the systems are in place, processes are in place, but there are regulatory approvals that becomes a challenge at some or the other point of time in the process of merger and amalgamation. If the due diligence before the merger has not happened well or it has not been done accurately, then the post-merger related issues may come into picture because of those lack of due diligences. Then apart from that, I think cultural integration is an issue in some of the mergers that happen. So yes, I think again, one of the challenge also, the shareholder and creditor sometimes even resist to approve such sort of proposal in the merger and amalgamation. So I think in fewer words, in conclusion, merger and amalgamation is one of a powerful tool for the corporates to plan such an action, but definitely it requires a lot of careful planning, compliance, regulatory compliances, and integration of strategies to make it a successful merger and amalgamation. Definitely, we will discuss the practical challenges with definitely coming into picture. So I think that is something I would brief out at this point of time, and I also look forward to the discussion that we are going to have. So over to you, Dipti ma'am, and thank you so much for this.
Yeah, Mr. Pala, just crisp because we are already late. Yeah.
Yeah. Good morning to all of you. I think we heard from both the panelists enough on merger and amalgamation, the intricacies. I will not take much of your time. But the only thing is the end result of the merger or amalgamation is what? Whether it is a successful merger, it is doing and achieved its target, or it is a failed merger. That is all it has to be looked into. When people touch upon it, you may be recalling it. Cultural issues. When the employees for the both organizations does not gel well, then what happens? Old timers will be knowing what happened with the Tata Oil mill when it is merged with the Unilever at that particular time. Basically, cultural differences that has got actually failed. Lot of people displacement. They have to open a separate company for placement of the people who actually came from Tata Oil mills and place them. That is what it has happened in that. Another popular case which did not go through culture on Tata Chorus issue, which was talked very highly about it, that has actually failed. Then again, we talked about the very various sectoral approval and other thing and all. There's a recent cases which was there some time back. In fact, if you people will be knowing it, SDFC life insurance and the Max life insurance, everything went on, but ultimately sectoral approval was not given to them. That is what it has actually happened. Similarly, IDFC and Shriram Finance, same thing which has actually happened in this case also. Regulatory disapproval has happened actually in these cases. Similarly, the Philcott and Snapdeal, basically it was a valuation differences which has actually came up. So like that, there are a lot of things are there. In addition to that, maybe you may be recalling it, even the Jet Airways wanted to merge with the Air Sahara because of the operational inefficiency that had got spoiled. Ultimately, anyway, Jet Airways nowhere today. So latest very things are all happening like that. So having get into everything right from the conception of drafting the scheme itself, that becomes important. Dipti touched upon very clearly. We have to disclose everything in the beginning. What is the aim? What is the thing? What is going to be happen? What are the arrangement? What is the thing? Everything will be point clear. So that necessary, because ultimately NCLT gives one single window approval. After getting the single window approval, we should not discover something is missed out again. We'll have to go back and do the thing. That is what it is going to happen. That Dipti has very clearly spelled out. I think with the able Deep Joshi has been handling these practical issues. He will take us through the what really happening in NCLT, what are the requirements, what are the procedure, what care need to be taken. All those things will take care of it. I also eager to listen from him what are the developments which are now happening it. Please raise your queries or your chat box. As usual, we will answer then and there only. At the end of the discussions, subject to time availability, you can also raise a question. We'll try to answer our level best. One more thing, please do not raise any specific issues calling for some sort of the opinion, etc., because we are discussing generally the procedure, law, interpretation related to that. Please avoid writing a specific particular issues or something that are where you need to take a what you call opinion from the folk. If that is the case, you can talk to one with Dipti Mehta or Deep Joshi, etc., and all this you can discuss. With this, I think I hand over the mic to the presenter, Deep Joshi. It is your time, Deep. Please take us through.
Thank you so much. Thank you so much.
You can't start video, the issue is there.
I'll just try, ma'am.
Yeah. And start sharing the screen also. And
Yes,
for your information, no Dvip, it's coming.
I know.
Right. Leave it. Friends, so sorry, he is not going to switch on video because everyone will be scared if he's
I'm having a very sparkling, bright Saturday.
No, we will think we are watching Alien.
Another reason that our future looks bright, ma'am.
So just to inform the participants, we are also going to take the webinar on reduction of share capital fast track merger next week. So be there with us for that. Okay, over to you, Dvip. Thanks.
Probably I've shared the screen. I don't know if that is
screen is very much visible. It is there. Yeah.
So firstly, thank you all, and thank you, ma'am, for the introduction, and thank you to the team, especially Disha and Prathamesh for the coordination part, and Mr. Bala and Ms. Ma'am Dipti ma'am for leading at the front with this webinars every Saturday. So today's topic is an insight into mergers and amalgamation. I will be only looking at, we all know with the when we talk about mergers and amalgamations, what we generally know is about the factual things that are mentioned in the books or the checklist, the compliance part, everything is in the books. But what I will try and major cover here is today with the very practical angle of what goes through majorly in the litigation aspect of it. I will try to cover as much. I've divided it into three parts, like the planning stage, the execution part, and the post merger scenes. So I'll try to cover as many legal aspects or practical aspects to it as to how, what are the challenges coming in, and what are the solutions that we provide or we generally have for those things. And we'll be leading with examples, but in case you have any doubts which are general in nature, as Mr. Bala sir said, if that is the case, you can obviously chat in. So starting with this merger, this is basically just what like a merger is: when two or more individual businesses consolidate to form a new enterprise, and when the merged entity takes a new name, ownership. So there are certain types of merger that we cover. uh, Coming to the purposes of merger, the common reasons that we see in is mostly administrative purposes, value creation, diversification, acquisition of assets, financial capacity, tax purposes. So all these are a general scenario wherein when the rationale of the merger comes into play, these are the things that the companies usually look into. This is also forming part of a restructuring plan, wherein the company, though even though profitable, wants to have some of the other entities who are not so profit making, to combine them with the synergies, and then try and capture the administrative front pay, whatever benefits that they can reap out. So I've divided the whole amalgamation and the whole process within stages. Stage one being the prerequisite to decide whether the case is fit for amalgamation or not. Then stage two, the favorite of all, estimation of the cost involved in the process. So these are the major questions that are coming in from the clients. Firstly and uprightly, that I face is the estimation of cost involved. Stage three is the arranging for prerequisites required for filing of the application with the NCLT. Here, I'll be discussing as to what are the requirements, what are the latest developments, and what are the latest requirements from the NCLT coming in point of view. Filing of the application with the NCLT. This is more of a something that will help the budding professionals, or even someone who is already practicing at the NCLT for IBC matters or otherwise, and who is looking into getting into this mergers amalgamation schemes. Stage 5 is course of action after filing application. Here I'll be discussing what happens to the litigation process, what are the questions that have been asked, what is the preparedness from the company's point of view as to what are the things that they should be ready with, or if that is a client perspective. Then stage 6 is course of action after passing of the first motion of the order by the NCLT. These are different stages that we'll come through, and gradually I'll be explaining it through the process and taking you all through the process as to how do we deal with those challenges coming in, and the solutions thereafter. Then the hearing of the petitions and course of action after sanction of scheme. So this is basically the post-merger scenes. So coming to stage 1, the prerequisite to decide whether the case is fit for amalgamation or not. So firstly, when I have an interaction with the client, it is generally they are prepared with certain things. Like, let's suppose they want to understand the jurisdiction first, and what now I'll discuss a general scenario wherein comes in, where the company comes to me, states that sir, we have two entities in Ahmedabad. Now this is for a particular group company structure, wherein they have a pan India presence, and they feel like for the synergies to be equipped with, they want to amalgamate certain corporates that they feel that are lagging behind, or whatever reasons that they may have. So now, giving you a very peculiar example of it is that, now let's suppose there are two entities in Ahmedabad, two entities in Mumbai, and let's suppose two entities in Delhi. Now for the administrative front, what they feel is, sir, we cannot operate these entities separately, and we want to merge it into one. Now that can be any of their reasons, but then what their first question to me would be is, sir, how do we do it? So firstly, looking at this scenario, without changing of the registered office of the companies, what I would suggest is that you'll have to file 3 applications separately in 3 states. Now, let's suppose where the companies are situated in Mumbai, they will have to file one application in NCLT Mumbai bench. For the Delhi entities, they'll have to file a separate entity in Delhi, and for Ahmedabad, they'll have to file it in Ahmedabad. Now, I give them 2 options. One is you change the registered offices of all the entities to either Mumbai or where the transferee company is going to be. Now, let's suppose, now I also just introduce the part where the transferee, because I'll be using these terms and the people who are not aware of it, maybe you can help with. So, transferor company is the one who's being merged, and transferee company is the one new entity that is going to be the present entity who's going to be merged with, the new entity in which the company is going to be merged. So transferor and transferee. So transferee is where the new entity is going to lie with. So generally speaking, wherein I have 2 options, that let's suppose there is one entity in Ahmedabad and one entity in Mumbai. I, for the very convenience of the process, would suggest that you rather go ahead with the changing of the registered office of the company first, the transferor company to Mumbai. Let's suppose if the transferee is in Ahmedabad, then in Ahmedabad. And if that process is done, what helps them is that I don't have to deal separately with the NCLT Ahmedabad, NCLT Mumbai, NCLT Delhi, and after that ROC Delhi, ROC Ahmedabad, ROC Mumbai separately, then RD, then the OL offices for each of the states. So that helps the firstly effectively on the process in a timely manner, and also with regards to the cost involved. So simply changing the registered offices helps them to eradicate all those costs and the time consumed there. Obviously, it is not possible for every entity to do that, and we have to eventually have that in separate jurisdiction as it is. We have no other options. Also, there is another query that comes in. Now, this is a very peculiar scenario wherein the company, the transferee company, already holds, let's suppose, 92% or 95% of the transferor company's shares. Now, the shareholding pattern looks something of this sort, that let's suppose the transferee company already holds 92, 95% or 97%, whatever the scenario is, and the rest of the percentage is either is in holding with some ex employees or some employees currently working. So in that scenario, what happens is, I'll tell you what are the benefits of merging a wholly owned entity into its holding company. Here, what happens is, when the scenario comes into play, this kind of a transaction between a wholly owned entity and a holding company, this can avoid major time constraints of the process, as in you can be dispensed with the meetings of the shareholders, you can seek dispensation of the seeking of the creditors meeting. All this cuts your time less. See, generally if there is a meeting to be conducted between those members of the creditors of the company, it takes about 3 months to complete the whole process, and the post compliance is part of it. So you automatically reduce those 3 months in the process of merging a wholly owned and a holding company. So in this scenario, what I suggest to the clients is that you can somehow make that entity a wholly owned entity and then get into the transaction of merger. Because firstly, you have the privilege of having that dispensation of the meeting with the creditors and the shareholders. Now, how do they do it? There are many ways to reduce those non-promoter shareholdings. Now, when I say that there is 90 to 95% of the transferee company already holding into the transferor companies, what we also help our clients is by reducing that share capital, or by making that entity a wholly owned entity through various mediums. Now, that can be specifically eradicating the non-promoter shareholder. There are also ways, so that as Dipti ma'am has said, that we'll have a separate webinar for this reduction of share capital, wherein I can go through the depths of the selective capital reduction and how do we play about it. So this is one of the scenarios and one of the pre planning stage pe jahan pe we discuss all of this. and how do we take it ahead, and how do we restructure the whole thing. So these are one of the things. Then coming to the coming to the stage one that I've discussed here, I've discussed many of things here. Understanding the necessity and objective of the merger demerger. This is one of the rationals that I need from the company. Now there are many companies जो बोलते हैं सर हमको बस administrative purpose के लिए करना है. Yeah, this is basically for some tax planning, but we cannot openly express this as tax planning or something. We have to show it in a way where it helps the NCLT process also understand. Acha, okay, this is for the administrative synergies or whatever the scenario is. Then the financial statements and annual return of the companies. This is a criteria which has been expressly mentioned in the provision as well as harped upon by the NCLT, wherein they require the latest financial statements and the annual return of the companies. They also go to an extent where you need to provide them a provisional statement for the last 3 months. Then the details of the immovable assets. Now this is one of the things that major corporates have, that they have a property in one of the transferor companies and they want to shift it to the transferee company. So now helping them, so what we do is we help them assign those assets. How do we transfer it? We guide them with regards to stamp duty valuations, whatever the queries that come in with regards to the immovable assets. How do we take it ahead? And everything has been discussed at this stage. Then the details of cross-holding and reduction of share capital that I discussed. Then the income tax provisions. So whenever I get into this merger transaction, there are a certain set of questions that I ask the client from my side to be very sure upon as to what I want from the client. A very clean thing, so that in the future prospect of the litigation, this does not hamper your whole transaction. So income tax is one of those things that I ask them, because see, everything goes seamless until the statutory authority arrives and says, okay, this is the report, this is where I need an answer upon. And when this thing goes into the court, this may take around 6 months or a year. We don't know about that. And jeopardizing the whole transaction just because we did not have a check upon the health check upon the income tax or any of those perspective, that derails the whole transaction and does not make any sense after. See, any transaction done within the time makes sense, but any transaction that loses the whole time frame, then the purpose of the whole merger gets derailed and it is eventually benefiting no one. So this is where I tell the clients that income tax provisions and income tax with regards to their demands or any of those income tax litigation, if pending, you rather disclose it to me, or if there is any solution to it, to rather solve it and then get into this transaction. So you be well prepared with those, any probabilities that are coming into the litigation process. Then the swap exchange ratio, the valuation that we discussed. So the swap exchange ratio or the consideration part of the merger, this is where you decide based on the valuation reports of the companies that what is the consideration that has to be paid to the other side. Then the goodwill and capital reserves. Now, these are the queries of the ROC and RD report that come in, where they need certain, what do we call, explanations or certain compliances to be followed while you have these reserves. And these are the queries that come in during the process of the litigation and the statutory approvals. Then the details of the pending litigation between the companies. These are basic list of documents that are required. Then if qualifications in the auditor report. So these are the things that I specifically go through so that I can answer those questions. I can have that ready, or if there are any justifications to it, I can be prepared with it so that when I go into litigation stage of it, I can explain to the NCLT, this is the case, this is what my answer to this is, and this is what the solution to it is. So that NCLT also has enough guidance to provide to us so that we can proceed ahead seamlessly.
Then when you talked about the litigation,
yes,
there are two issues. One issue, the litigation with the outsiders, other than the thing. That's why I can say the issues with the regulator, that is ROC.
correct.
Who's going to give the approval for the merger, no objections.
Correct.
So here, the issues which are pending with the ROC, that need to be sorted out first and foremost, then only you can proceed with the further, otherwise nothing will move forward. if you have any show cause notices, if you have any adjudication pending, if you have any compounding applications to be filed, etc. For everything, you have to actually convert and put and file the compounding application. And ultimately, not only that, in your incorporation, the document what you are drafting the scheme itself, it has to say that surviving entity will take care of all the things after the merger is taking place.
A very
Then only,
interesting question. I'll tell you a peculiar example of we are facing in the NCLT. These are hurdles that we think that acha okay in pe kuch notice आई होगी ROC की and it is still pending. So what happens in one of the cases that I saw was that one of the entities, it was a listed entity that was getting into a merger, and what had happened is ROC had issued a notice to them, and the inquiry was pending. And I believe we had the same stance that, sir, I mean, we explained it to the NCLT that this is a scenario where the transferor company is going to be merged into the transferee entity. And if that is going to happen, all the inquiry, all the proceeding that has been pending with the transferor company is going to then be represented by the transferee company. To which the NCLT responded that no, if the transferor company is dissolved as per the merger provisions, what happens is the ROC cannot issue in the same name to the present transferor entity. To which we had the same stance. Okay, madam, this is what is going to happen, and all the litigation, be it pending or during the transit, will be then taken over by the transferee company. To which the NCLT responded that no, nothing doing. We will wait for next 3 months for ROC to file a report and come with a basically come with a reply to whatever is going on with the proceeding. So this suddenly hampered the whole transaction process, because now if it is a listed entity that is going into this merger transaction, there are a lot many things depending, and any such news can directly affect the pricing of that company in the listed entity. These are very price sensitive information that that if passed on, it hampers the listed entity in a big way. So to that, the council was also taken up surprise that I don't know where is this coming from. Then 3 months passed by, another hearing took in. Another date was sought out by the ROC stating that we need another month for this. To which aggressively our council also retaliated, stating that this is not fair on us also, that we are withholding the whole transaction just because ROC is yet to file a report. To which again NCLT had sought out, okay, we'll give time to the ROC to file a report another month. To which now the client had to take a stand. So they went to the NCLAT, stating that we have given our stance of stating that whatever the transfer company proceeding is, we are going to take care of it by the transferee company, and we are ready to file an undertaking to it by stating an affidavit to it. Then the NCLAT then sent us back to the NCLT, stating that NCLT should be issued disorders, you should not wait for this. So these are very peculiar instances that we think is very common. We'll have this stance of stating that it will be handled by the transferee companies. But there are certain this peculiar instance coming in, which was actually very surprising for us also, as to how can a NCLT then direct us to wait for that report. So, sir, we say that this is the common stance, but ऐसा होता नहीं. Sometimes the NCLT bench is too tough to deal with in that scenarios. We tried everything at that point in time, but we had to go into an appeal to come back to the NCLT, stating that we cannot wait for that another 6 months for the ROC to file a report, and then we go ahead with it.
In fact, when we had an issue, the same thing which has actually happened with the NCLT, because we tried to merge about 12 companies into one company. In 2 of the companies, there were issues. What has happened is, ultimately, after talking to the NCLT, they told very clearly, all the show cause notices, whatever is pending there, please file adjudication applications or compounding application, whatever it is. Then what happens is, those applications which actually go to the ROC, you give undertaking. All these things will be handled by the surviving company. That is how we sorted out the case actually. Yeah.
Correct. This is the exact stance that we took, sir. And surprisingly, this was one of the scenarios that took us all by surprise, and we had to do this. Now,
Correct.
client is not going to listen to us stating that nahi, aap NCLT se mana. Matlab, see, whatever I said to the client is going to retaliate by stating that nahi, you have to do something about the whole process.
Yeah.
No,
That is one thing.
exactly. One of the participants has said that in case of litigation, there is no risk because it is totally transferred. Yes, exactly. We were also telling that is the law. It will get transferred. But the authority should get convinced. We know the law. The law is not accepted by them.
Exactly. So
It
there are
is, that is
there are
clear in the
certain
law.
things.
It is not the issue.
You
So,
know, what happens is, in case
So
of the
actually,
litigation,
practical difficulty, very unique situation comes.
So I'll tell you, there are certain comments coming into this that in case there is litigation, there is no risk to transfer a company. All litigation will be can transferred. There is a judgment of Supreme Court. So all that, Mr. Rajarshi and Ms. Kanchan, we had stated the same challenges. We presented the court with same our submissions, but sometimes the court is very adamant, and they side with the statutory authorities a bit too much. But we at that point need to decide that do we need to please the court at that point in time, or do we need our clients benefit in that. And looking at that scenario, we didn't want to uh, hamper the client transaction, and rather we go to the NCLAT and then rather get that direction from there. It is obviously a costly process, but this is what was required at that point in time.
you are actually right, because what happens when you take litigation, when the company changes the name or company merges with the other company's name, automatically the things which are concerned with it, the new company takes over everything, or its surviving entity takes over all those things. But
So
the only
I'll tell you
question,
very honestly, what was happening is the court at that time was siding with the statutory authority in a very, we know that how being brutally honest about it, our statutory authorities are lacking somewhere because of there can be a voluminous work that they are handling, then there can be shortage of staff, whatever we call it. But the statutory authorities are ineffective to the part that when it comes to report filings and everything, they have been delayed about it. And there the court was a bit lenient towards it, and siding with the statutory authorities at that point in time. But we being a listed entity, we could not take that risk, delaying the whole transaction with more than 3 months or more than 4 months, just because there was no report filed by the ROC. So at that point in time, we needed to take that professional decision as to, be it costly or be it whatever, this can be taken through this also by the court, that acha, they've gone to the NCLAT and come to us with the directions. But see, that is what the scenario is, that looking into the client's benefit and what was required at that point in time was a specific answer to those challenges. So that is how we need to take care of that.
I think with not only litigations, in fact, in cases of non-compliances, which are mere, negligence on the part of the company,
I'm coming, and I'll be coming to that, Mukti. And
Yeah. So this is also a place where the authorities' approach is very different. I mean,
yeah.
so yes, as you
Very,
rightly said,
very
it
tricky,
becomes a task to deal with them, and just
It's
to
very tricky
on the
to
basis
deal
of
with
the
them,
law.
and keeping in perspective as to what the requirement at that point in time of the transaction is very crucial. And one decision not taken in time can derail the whole transaction by 6 months or more.
I think you can continue, because also you are taking appointed date, effective date, right? Dvip?
Huh?
Appointed date, effective date also you are taking, no?
yeah, he is going to
Yes.
discuss.
Now we're just
Yeah.
coming to the
So
drafting.
the other questions are relevant to that, so I'm not taking that. You can.
Yes,
No,
yes,
we won't take the questions now, because he is going to discuss in future presentations. So let us wait.
Yeah, better we do that. Yeah.
Yes. So I'm just coming to that. I'm so sorry. So this is the stage where drafting of the scheme comes into place. So now when I say scheme, this is an umbrella approval of certain things that the corporates want to take in one go. Now when I say an umbrella approval, means this is a composite scheme. There can be a composite scheme where there can be reduction of share capital, there can be the scheme approval of scheme of amalgamation approval in that. There can be change in name of the company. There can be change in the authorized share capital of the company. There can be change in the articles of the company. So all that which you need a separate process approval for these things in a scheme, when we call it a composite scheme, it means that there is an umbrella of all of the things that you can put in, and in that one application itself you can have all those approvals, so that the company does not waste its time in the process approval separately. So this is where the scheme is of prime importance. See, now whenever I talk to my client, I ask them to be, see, what happens is I have seen this in many of my clients, and in general, that they are too dependent on the consultant to tell them as to what they need. But I always have them, in consent, that you need to discuss internally with all of your hands of management, that you sit with your finance team, you sit with your accounts team, you sit with your legal team, you sit with your compliance team, you sit with every other department of the team. You come into synergy first internally, you sit together and see what the company requires at that point in time. There have been instances, sir, that ma'am, that I have come across where they say कि sir हम क्या appointed date ले. मैंने बोला, see, this is not my question to be answered. See, if you ask me, I would rather say कि अगर मैं आज file कर रहा हूँ तो you take a date as 1st April 2025. I don't mind about it, but that should be a decision that has to come from the management, because you have to look as to, now I'll just give you a brief as to what an appointed date and what is an effective date. Now, appointed date is the date from which the books of the transferor company and the transferee company is going to be merged, and from that date the books of the company will be consolidated. But effective date is the date when the final order of the NCLT comes, and that order is filed with the ROC. So the date of filing of that final order with the ROC is the effective date. Now there can be a gap of anything. Now let's suppose my appointed date is 1st April 2025. My effective date can run probably after a year also, after 2 years also, after 3 years also, after 4 years also, whenever the approval comes. There can be a delay in litigation process, whatever the challenges come upon. So there can be a delay in that. But your books will be consolidated as in effect from 1st April 2025. So what generally people do is they have this provisional things, provisional accounts being created parallelly of a consolidated view of the whole company, and then the effect can take over. Now for the appointed date also, what I do to my client, what I advise to my clients is that you can keep it any date, but not preceding more than 1 year before the filing of application. So there is a ROC circular in place which states that, now let's suppose we are in April 2025 and my client says that sir मेरे को 1st April 2024 रखना है. So I don't mind doing that, but the date that I file the application should be 31st March 2025, so that it is not preceding more than a year before the filing of application. So there is a provision which says that it can be preceding more than a year, but you require a very specific justification to it, stating that it does not harm any publicly, it does not harm anyone, or it does not be prejudicial to any of the stakeholders. So you can have it preceding more than a year behind also, but that should not be prejudicial to any of the stakeholders involved. So keeping in mind, what I rather suggest is you rather keep it within a year, so that it is not a litigation hurdle to me also. I don't need to provide any added justification to it. But if it is working in your favor and it is something that that is not prejudicial to any of the stakeholders, you can take in any date preceding more than a year also. Okay. Now coming to the drafting of scheme. Now it is basically divided into three folds. The introductory part, wherein the details of the transfer and transferee company takes in. the incorporations, the register office details, the objects in memorandum association of the companies, the jurisdiction, the facts of the case as to the rationale of the merger coming in, the nature of the business, the share capital, and everything. Second part that comes into play is the operating part. Now here we discuss the major portions of it as to the appointed date and the transfer of undertaking processes. Then how are we going to transfer those assets, the debts, liabilities, licenses, approvals, employees, whatever the main ingredients of the scheme are. Then the what are we going to deal with the contracts and the deeds and the agreements that that are some major agreements that have been in place. So how are you going to deal with those? Then it comes to the issue and allotment of shares. Then you can also have the reduction of share capital done, the change in name of the entity, then change in the registered office, whatever that you feel that you need a blanket approval for. All this forms part of the operating part of the scheme. This needs to be very carefully drafted, and this needs the maximum management intervention at that point in stage. And this is where I tell to my client that you need to synergize, and you need to combine your teams and sit together to discuss the operative part of this, because this is where you're going to give effect to the entity, which is going to directly affect the workings of the entity. Then in the final part is the prayer and the relief part, wherein you seek an approval and particulars of the bank draft, evidence in the payment, and everything. So this is basically what a draft scheme would look like. Now everything that falls into the operating part, what I do with my clients, what we do with our clients is basically we suggest certain clauses to them as to whatever works in their favor based on the financial statements that they have provided to. Looking at the financial health of the company, looking at whatever forms part of their financials, I suggest certain things that that they can help restructure the entities. So this is where our part also comes in. But for that, what I need from my client is to be prepared as to you look through internally, through the provisions, through everything that can help you get through this. Coming to our favorite part, the cost and the fees of the whole transaction. So I'll tell you what is basically forming part of the whole process. First is the statutory fees. That is the fees that we file with the NCLT. Then the auditor's fees coming into play, the advertisement cost. So what is an advertisement cost? Is a public advertisement that has to be made during the litigation process. This I'll come to as we proceed through the process gradually. Then the professional fees for the valuation report. Also, I have not added. I think I have not added my fees only. So there is a professional fees for the professionals involved. The chairman and the scrutinizer fees in case the meetings are held. This I'll discuss in detail. Then the payment of cost to regional director and the official liquidator. Then the stamp duty on transfer of assets of the company. Other incidental expenses, printing, stationery. Now this other incidental expenses, people will think, why are we including it here? It is some hardly any petty expenses that we need to take care of. But I'll let you know as to why this is a huge cost, because sometimes what happens is the printing and the stationery expenses runs into lakhs. Because now let's suppose an entity has more than 10,000 creditors, more than 5,000 shareholders, or whatever the instance is. You need to send them notices. Along with that, there are annexures running into 10 pages, 12 pages. Now imagine having 10,000 creditors, you need to send the notice to. So the printing stationery cost itself runs into lakhs. So this is a major cost that people generally do not think that okay, हाँ ये तो ठीक है, ये शायद इतना बड़ा expense नहीं होगा. But I always tell them कि अगर आपकी creditors ज़्यादा है, shareholders ज़्यादा है, it is going to be a very major expense. Then obviously the professional fees. This is just a the cost structure. The professionals fees obviously not we're not sure of.
For the printing to the creditors and shareholders, I think not only to them, even when it goes to authority, they even ask for the printed copies of all the consents received from creditors and shareholders. So that also is counted in
And
the.
now let's suppose my pet. So what happens is when we serve the petition to the statutory authorities, now
Yeah.
my petition, if it runs into 2000 pages along with the annexures, and imagine having those printed 5-10 copies for each of those,
Each of
statutory
the
authorities.
companies involved. Yeah.
It runs into huge numbers. So I mean, everybody watching, please don't take this printing and stationery cost as a very minimal cost. It's a huge cost to the company. Then the application to the NCLT, that costs about 5,000. This is a basic statutory fees of the NCLT. Then the auditor's fees, that is average of last year. Advertisement cost. So now if you're holding a meeting, this cost comes twice, 25 to 40,000. Now this ranges upon what happens is during a public advertisement to be made, it has to be made one in the regional newspaper and one in a English newspaper across India. So now let's suppose if I have an entity in Mumbai, Ahmedabad, and Delhi, and I'm merging it there, I have to make an advertisement in Mumbai, Delhi, and Ahmedabad, and each of those public advertisement may cost about 30 to 40,000. So this is generally the cost idea of it. Then payment to the RD and official regulators of it. Now, prerequisites for filing an application. This is very on the professional side of it, as to if there are any budding professionals who are intending to file the application with the NCLT, or even if it is a company. From the company's point of view, this may help them. So basically, preparing a checklist. So what I do with when I get into my clients is I send them a checklist as to what is the timeline process involved, what, where, and when do I need it, and we discuss this in detail so that the process from the company's point of view and my point of view is seamless. Then drafting of scheme, then the conducting of board meetings. So conducting of board meetings is another secretarial point of view. I think Mukti can knows about it, that also is a task.
Yeah.
Then the appointment of registered value of a finalizing of swap ratios and the valuation report. Then the consent of shareholders and creditors. So I'll tell you one more thing aspect about the consent of shareholders and creditors. So whenever I get into a transaction wherein I need to discuss this with my clients, my initial questions involve asking them about the number of shareholders and the number of creditors involved, be it secured, unsecured, whatever, and how easy it is to take their consents, and how easy is it or how convenient is it for us to do that, because now the consents look two ways. Now one is an affidavit consent or a general consent where there is no affidavit involved, or if there is no possibility of a consent to be taken from the creditors or shareholders, you need to as per the direction of the NCLT, you need to have a meeting arranged for, and then there will be a voting process. But I would always suggest you get the shareholders' consent and the consent of the creditors pre-hand before going into the application filing. What it helps is that you can seek dispensation of the meetings based on the consents obtained from the shareholders and creditors, and it also helps you reduce the timeline or the time frame involved in the process. Now let's suppose if I have to conduct a meeting of the shareholders and the creditors, I have to give at least 30 days notice to each one of them. Now I will also have to look at the availability of the directors the availability of the shareholders at that point in time, if that is a feasible time to be have that meeting done. Then availability of different operations team and everything involved. So I take it as a time frame of at least 3 months of doing the process with regards to compliance following by the NCLT and the conducting of the meetings and the post compliance part of it. So I generally take in 3 months as a natural determination for what happens during the process. So you eliminate automatically 3 months of your transaction, which is a huge thing, by the way. It looks like अच्छा 3 महीने तो कम हुआ, but at the perspective of the corporate who wants to end up this transaction within 6 months or 9 months, they know the value of the time of a sense of that transaction. So this is a very important part, and the consent look two ways that I told you, that one is the affidavit part of it, and one is a simple consent. Now, if there is a closely held private company or a closely held public company also, in that, if it is possible, I ask them to get an affidavit, a consent affidavit in itself. That means that an affidavit means it will have a stamp paper, it will have uh, a proper affidavit consent stating that I am aware of the facts and I am giving my consent to it. Or else it will be a simple letterhead consent of the creditors. But now what happens is, the major challenges that come across the entities is their creditors are sometimes not just in the state but are in a pan India presence. So how do I take consents in a affidavit form from each of them? देर इज नो क्रेडिटर ऑफ यू वेटिंग, अच्छा हाँ आपको चाहिए, मैं काम करता हूँ, मैं खुद का स्टैम्प पेपर लाके आपको मैं एफिडेविट देता हूँ. देर आर नो गुड पीपल लाइक दैट in that scenario. So you'll have to arrange for that affidavit for each of the state. Rather, what you do is you rather take a letterhead pay consent of those creditors. That is also a task in itself, because getting money from the creditor is a different part, and paying them and getting things from the creditor is a different part, and getting consent is totally a different task altogether. So this are the certain challenges that from the company's point of view they tell me कि सर ये बहुत difficult है, मैं ये process करूँगा उसमें 3 महीने चले जाएंगे. Rather आप ये meeting कर लो, जितने लोग आते हैं ठीक है, उनका मैं consent लेके we can move ahead. So one of the challenging areas of taking the consent. Also some shareholders are abroad, वो abroad होते हैं, तो फिर वहाँ पे उनका shareholders का consent लेना. Then the apostille system comes into play, wherein you have to get it apostilled from the embassy. फिर आपको यहाँ पे लाना है, फिर यहाँ पे आपको provisions, you have to follow the procedures. So all that is a huge thing. So when I get into the transaction, I tell them that you keep these things in timeline, and you be prepared with a timeline, keeping provisions and keeping enough buffer period for all these things and or documents to be prepared for, and then go into the transaction.
Taking a consent in a private company and the unlisted public company could be easier, but when it comes to the larger company and the listed companies, it will be a bit difficult.
Huge task.
Yeah, I would like to add something here, Deep. There are 3 specific points I would like to add. In specifically creditors, when you said for the affidavit and all, in my experience, I have seen, in fact, if a creditor also is a foreign creditor, in that case, government has asked for a attested copy of consent, it on their letterhead. And specifically in case of shareholders, if it is not a listed entity or be it a listed entity, there are number of classes. In one of my past merger, I had 27 classes in one company. So in that case, the question comes, do we have to conduct 27 shareholder meetings? Can we conduct a one single meeting of a shareholder, then arrange, approvals? What about the scrutinizer report? It also plays a pivotal role in taking the consent of shareholder. And in some cases, I have seen authority asking a statutory auditor certificate also on the list of shareholder and creditor.
I'm coming to that. So one thing that when it comes to, so Mr. Anuj also here has mentioned it, that there is a way where you only have this large payments done. So what we generally advise to my client is that, let's suppose their payment cycle is on the first of every month. So what I do is I have to mention a list of creditors to the NCLT. Now there are 2 more documents required. There is a list of shareholders and the list of creditors, which needs to be duly certified by a CA, and you need those specific consents from them. So now what happens is, generally what we advise to our clients is that, now let's suppose your payment cycle is on 1st of every month. What you do is you do major of the payments on that day, and then whatever is left is a very small chunk. I'll ask them to make those payments very in that very cycle itself. And when you take the list of creditors, you take it from that day onwards, so that the list or that chunk of major creditors is over, and you can then conveniently take those creditors in the consent part. And what happens is now there is also another catch to it. When we file, now let's suppose I'm filing an application on 31st March. My list of creditors should not be older than 15 days of filing of the application. So this is the NCLT requirement wherein, see, अभी if NCLT has seen your application और उसने देख लिया कि नहीं ये older है तो वो पूछ लेंगे आपसे. But if it skips the NCLT's observation, then you are okay with it. But what I generally tell my clients is that you plan it in a way, you get a certificate from the auditor, from the CA, in a way that the list is not older than 15 days from filing of the application before the NCLT, so that you are good in the eyes of the NCLT as well, and your payment cycle is also done. So there is a lot of planning and a whole thing going on, so that everything cleans up and you're also good in the eyes of NCLT. And this CA that I'm talking about can be any independent CA, not your statutory auditor. Okay. Sometimes we have seen cases where the NCLT asks for a statutory auditor also to say to give that, but you can have it from an independent CA as well. Then there is another requirement of auditor certificate for the accounting treatment under section 133. This has to be strictly be given by the statutory auditor of the company. Now this is also a task. Now what happens if there are any big fours handling your entity? To get certificate from them is also a huge task. So as
You have
I
to
told
factor
you,
in a lot of time they put in to do the due diligence.
so I'll tell you, Mukti, I have had instances where I need a simple clarification from them to proceed ahead because NCLT had asked for that.
Correct.
They
In
took
my,
more than
one
3
of my
months.
experience also, my merger got delayed by a month's time because of my auditor certificate was not in place, and that certificate was not even a difficult certificate. It was something between a relationship of a holding and subsidiary, which is anyways a part of your financials, your quarterly result,
Correct.
everything. So yes, this is one of the tasks which actually delays your process by some other
And
time.
imagine having everything in place and your auditor does not provide the certificate in time.
That's a task.
You need to redo the whole process again and redo the whole timeline to get in and the timeline in place so that auditor can come. So I always say this to my client ki if you have a big four auditor in place, you take all those buffer period in consideration to it and then go ahead with it, because you don't have the time to redo the whole process again. Because see, as I told you, there is a 15 days time of that auditor का आपको चाहिएगा certificate. So
like you said, creditor के list का 15 days law में there is nowhere mentioned, but there are certain internal timelines for the authority itself कि उनको ये gap नहीं चलता, वो gap नहीं चलता, which everybody does not know even before starting the process.
And see, NCLT holds discretion to that part. Now they can seek for, वो बोलेंगे नहीं मेरे को 15 दिन पहले का ही चाहिए. So what are you going to do about it? You can only handle the controllables at your end. But anything coming in that you are not very sure of it, then you have to have that we are in your hands, in the hands of court.
Yeah, many times it is not going as per what you read actually in the paper, what is written in the rules, because it all specifically with the authorities who are actually dealing with it, they will put their specific conditions, you have to fulfill it. That is
so I'll tell you this instance as well, wherein the accounting treatment certificate given by the auditor in the first instance, when the whole process is done, when the final order has come, there is another observation coming from the same auditor stating, नहीं ये accounting treatment नहीं चलेगा. You need to amend this accounting treatment from the NCLT. Now imagine you going through the whole process for a year and a half, taking the approval of the NCLT, and then your auditor stating, नहीं ये accounting treatment जो पहले था ना, now it is not applicable. You go ahead with the NCLT, you amend the scheme, and then come to me. So this also we have handled, sir, जहाँ पे हमने accounting treatment के लिए अलग से एक amendment scheme file की है. Now imagine that amendment scheme also has taken 6 months.
Because you have to do the whole
process.
You have to go back to square one, even for the amendment to the scheme.
We can skip the major portions if the NCLT at its discretion allow you to do that. But
when you actually talk about the big four, there are two issues are there. One issue is, okay, time taking is there. Another issue, cost of aspect of it. Because they have their own cost structure and they also have their own working methodology, because they will say this due diligence has to go, it has to go to this subcommittee, it has to go there, it has to get approval, then only things will be issued. That you very nicely said it. In fact, people have to forecast well in advance if any such things is required from the statutory auditor who happen to be a Big Four.
So, Mr. Rajiv Bhatia is asking us, Mehta can develop a complete ecosystem. So we have that, sir, and that is how we are learning through the process, and how we are advising them as to not commit these mistakes in dealing with those transactions. And sir, this is an evolving process. The hurdles are unseen also, and what we do is we are only learning through the process, and whatever we can do at our end with regards to checklist or with regards to any of that system in place, what we generally do is, so we are prepared for everything. But now if there is any unforeseen litigational circumstance coming into play that we cannot answer to it, then that is a different issue altogether. But for whatever be the reason, whenever we pitch it to our clients, we have our the studies in place, and everything will be done through those studied material itself.
Your mindset in this whole process will be expect the unexpected thing. That's all.
Absolutely,
Nothing else.
Absolutely. And then the authority to professionals for everything. Then the filing of the application with the NCLT. Now, this I said that where this timeline is important is that if your appointed date is within a year preceding backwards, then it is fine. I had one instance wherein the guy asked me to have it on 1st April 2024, the appointed date. So I told him that I need to file it on 31st March 2025 itself. I cannot be a day late in the filing of the application, or else I'll have to provide a justification to this, because then there is an ROC circular in place, as we discussed. So everything was on time, but due to the technical failure of the NCLT at the end moment, we had to file only a day late. That was 1st April 2025. So now for that one day also, I'll have to justify to the NCLT stating that why we had this delay. So this is where the the timeline, how does even a one day change the whole circumstance of the whole litigation part of it. So here what I'm focusing on is that timelines with regards to this process is very important, and even a day's time taken by the company or by the consultant can affect in a huge way to the outcome of the litigation process. And every time when I deal with my client, I tell them the importance of this timelines, that this has to be maintained by your end and by my end very strictly.
It can be said that there are 3 applications, 3 stages of 3 times we are filing application. Each hearing is crucial. We are waiting the opportunity. And if this things is there, 1 or 2 hearing you lost in giving this explanation. So that to be kept in mind, because each application has so many hearing dates. So your process, your frustration, your patience will be tested. Yeah, thank you.
I'll also add to it, ma'am, that the patience held by the NCLT court is a very small time frame that a counsel gets. We get a very small time frame to please the court at that point in time, stating that भले हम 15 मिनट की बात बोलने वाले, but we'll only ask for 2 minutes. Then 2 minutes, how do we extend it to 15 minutes? And then how do we deal with their patients at that point in time? And if we have any of those laggings in our application, then it affects us tremendously.
Yeah, we have to. Yeah, sorry.
And that should be avoided. That's it.
Yeah, so it should be that as if we have to say our application is perfect. Everything what you are up till now you have demanded, we have already given. But still there can be something new in the bill. So we are ready in that kind of thing when we go for mergers application.
Like rightly said by Anuj, if the authority itself changes, I mean, there are, officials changing in the NCLT or RD. Every authority have a different mindset, different approach, different lens put in on the application. So it's sort of a fresh, viewpoint given by each of the authorities. So again, that takes a lot of time.
Yeah, that only I said, no, that our application is perfect, comply all things which up till now court has asked. But still there can be something new. We are
different, that we can expect.
We have to mentally get stressed that way.
Also to add to it, I'll tell you why keeping the client informed about the process. See, on a professional side of it, it is very easy to ignore the client stating के चलो यार इनको मैं कहाँ litigation process समझाते बैठूं. But as अभी now जैसे अनुज जी ने बोला कि that he has mentioned that हमारे केस में NCLT का बेंच ही चेंज हो गया and that delayed another month. Now imagine you have not explained it to your client as to how the litigation process. See, it is not important that the client will know as to how the litigation works. But if you keep the client informed as to how does it totally work, it will then favor you in such scenarios. I've faced this and I've learned through the process, madam, that if my client is informed about each step of the process, it is easier for me to give him an explanation as to this delay is not because of me, but it is because of something that is not in my control. And this I have noticed within my practice that I did not used to get into the intrinsic details of the litigation and how do I explain it to the client. But later I found out that if I keep the client informed about the process, he is more secure. He thinks that acha, okay, I am in good hands, and that is of prime importance to me at that point in time, because then वो मेरे पे नहीं आके बोलेगा कि सर आपकी वजह से हुआ है, or he'll keep on hampering me with those questions that sir ये क्यों नहीं हो रहा है, क्यों नहीं हो रहा है. So on the professional side of it, what I would suggest and would give my input to the professionals is that always keep your client informed about the process. It will help you only in the long run, so that you don't have to answer those questions to them in later on, because they know कि क्या process चल रहा है.
The comment box also somebody says actually NCLT process, it made a big hurdle because of the change of the NCLT members so frequently. He has put it here.
Yeah. And then what happens that company stress on the particular compliance in an exact way as the court directs. That importance is given and importance to the timing is given. That helps it. Yeah, Tim, carry on.
Yes. I'm so sorry. This was done right. Acha, this is more of the the professional part of it, wherein the how is the printing done, or the single side print. I had a question also with regards to this. I'll just take it up because it is relevant at this point in time, if that is okay. It was by
it is very much relevant, because what happens is when we go to the different NCLT, they call the different things. If you go to Calcutta, they want the margin to be left in the left side. When you come to the Bombay, they want the margins to be left in the right side. Then they have the specific thing. Some of the NCLT, they have the margin to be left in both the sides. It is very, very important. If you miss out that, your initial applications and rectification process takes a longer time. Yeah.
So there are two questions to it. What I want to answer at this point in time, one is of Mr. C.S. Chandrasekhar, and one is of Mr. Anuj. So Mr. Anuj here is asking printing on legal paper plus no back-to-back printing allowed by the NCLT for easy scanning. Okay, so this is basically he helping us out by telling us that what is easy, and this is what the process is basically. Yes, Mr. Anuj. And for Mr. Chandrasekhar, what is the concept of notice of admission, and what is the long citation, short citation? 3. Achha, what is long citation, short citation? Okay, and what is the difference between CP and CA? So I'll answer those. So concept or notice of admission is basically, notice of admission is directed towards the NCLT, wherein we address to the NCLT that we are filing this application and you kindly admit this application. So this is an admission request to the NCLT by the lawyer or by the company applicant company, that kindly go through this application and you kindly allow us to admit this application, wherein you are seeking a number of prayers to the NCLT, that you are either seeking dispensation of the meeting of the shareholders and the creditors, or you are seeking a direction that a meeting be conducted of the shareholders and the creditors. So this is basically what the concept of notice of admission is. This is a part of a very procedural. See, what differences a civil litigation and NCLT litigation is. NCLT litigation is more of a pro forma based litigation, wherein there is a standard pro forma given by the NCLT, wherein you just need to fill in the details about the application and everything. A civil litigation, on the other hand, is a essay writing competition, wherein you run into pages, you write all the stories, all the dramas. You are allowed to do that. But an NCLT application, on the other part, is a very precise proforma based, proforma based application, wherein the brief facts are it is a very crisp form of submission to the NCLT, a very point on point description of the facts. And what is the difference between CP and CA? So CA is basically a company application. Now I'll just briefly explain it to you. When an applicant company goes to the NCLT for the first time, that is an application admission for the company. At this stage, at an application stage, that is the first motion, that is a CA. And in that, what the company at that point in a merger is seeking, either the dispensation of the meeting with the shareholders and creditors, or asking the NCLT to convene a meeting of the shareholders and the creditors. So this is basically a company application stage. Now, what is a company petition stage? Company petition is what is filed afterwards. Now, once the meeting is done, or if the meeting has been dispensed of, there is a second motion filed for company petition, wherein the company is then stating that देखो हमने shareholders and creditors की meeting कर ली है. Now I am coming to you with this petition to admit my prayers and kindly allow the scheme to be proceed with. So this is a approval petition. So if I hope this answers your question, Mr. Chandrasekhar. Also to Milan Shah, if that this is irrelevant at this point in time, can we obtain a certificate from any practicing chartered accountant certifying the list of shareholders, this net worth certificate and details of the demerged undertaking? Yes, I have answered this, that you can have it from any practicing CA. With regards to list of shareholders, list of creditors, net worth certificate, I also highlight the net worth certificate requirement. When I told you previously that when there is a wholly owned and a holding company merger happening, there is a requirement of a net worth certificate to be provided, which the NCLT asked for, because we are seeking dispensation of the meeting of the shareholders and the creditors. So at this stage, the net worth certificate is required. And yes, sir, that you can have it, Mr. Milan, we can have it by an independent chartered accountant. There you do not need the statutory auditor unless there is a specific NCLT directive for it. Mr. Kangayam Ganesh, I'll come to that question. Coming back to our presentation here. So this is basically more of the procedural requirements of the NCLT, the margin and the signature and initial on every page. So now what we also have, Bala sir, we also had this request coming from our client that सर हमको हर एक पेज पे इनिशियल और सिग्नेचर करना पड़ेगा क्या? अरे आपका पेटिशन 2000 पेज का है, मेरा डायरेक्टर नहीं मानेगा, मेरा डायरेक्टर बोलेगा कि 2000 पेज पे मैं इनिशियल नहीं करूंगा. So अभी मैं ऐसी रिक्वेस्ट आई कैन नॉट कंसिडर. So there is no choice, but you have to initial on each and every page of that application. And the signatures and the notary is also mandatory. I get this question also, that sir notary भी 2000 पेज का ही कराना है. मैंने बोला yes, we have to do it.
This is the mandatory requirement. There is no other go than to go with that. Because in fact, I'll tell you one thing, when we had gone for the 12 companies petition, we have spent 2 full days calling the directors, asked them to sit there, sit along with them, and putting a stamp, getting the thing, get the notary, get the notarization done, everything and other thing and done. This is the mandatory requirement before you go to NCLT. There is nothing, no escape.
I've seen the company secretary department complaining to me कि sir अभी ये मेरा director को बोलूँगा ना, ये मेरे को sign करके देगा नहीं 10 दिन तक.
Then forget about the merger. That's all. Simple.
Yes. So I told you that internally you need your whole team in the company to be ready with whatever is required. आप फिर बोलोगे कि नहीं ये नहीं होगा, ये possible नहीं है. So everything can be worked out, but only if you. So I come up with other this also, that अगर आपको sign नहीं करवाना है ना, तो so initial discussion में only what I do is I ask them कि आपके board resolution में make someone else an authorized signatory.
Correct, correct. If you want to do that, make
Yes.
someone specifically authorized for this particular purpose,
Yeah.
and tell him so that he can do it.
So now,
for you.
sir, this is something that I learned from experience. So this is what I have kept in my checklist also. That अगर ऐसा कोई बोलता है तो my team will then ask them कि ऐसा कुछ problem है, तो rather you give them authority in the board resolution who can sign it and initiate it as soon as possible. So this is some practical thing that everyone can endeavor, or whatever they can hand over with. Now this is the course of action, and after the filing of application, what happens is, so in the initial first hearing of the application, what happens is the NCLT asks different sort of questions. Firstly, with regards to the capital structure of it, the shareholders, then what is the business of the companies, then what is the rationale of the merger. So it is basically more inquiring questions pertaining to understanding as to why the merger is happening. See, the NCLT at that time is very, in a very inquiry mode, as to they want to see if there is anything fishy going on, if there is anything that they need to be very cautioned with. So they will ask you many things. They will go through the financials of the entity. They will ask to the fact ke how are you. I mean, now just giving you a very a simple example. What we did was, there was a non-operative entity that was merging with another company with a different business altogether. So the questions asked by the NCLT at that point in time was that for the past 4 years, your entity is not working, but there is some income coming from X operations, and there is some gambling, horse expenses. So basically, that entity was into horse racing and its all entities. But during the COVID period, all of this was closed. The horse racing and everything was closed. So generally NCLT does not get into the depths of it, but they suddenly ask के sir एक बात बताओ 2020 में तो ये सब बंद था, तो how do you generate this operation income from that horse racing or something of that sort. So I was also taken aback कि यार ये तो मैंने भी नहीं देखा, and then I had to take instructions from my client कि अच्छा ये how do we answer that. Then they told me, okay, sir, this was an internal process. This was an internal expense coming into play. So, what I want to make people understand here is that they go into very minute details at the application stage, wherein they are very in a very inquiry mode of things. They want to know if there is something fishy going on, if there is anything that they can be cautioned with. So at this stage, the council needs to be prepared with everything. The the capital pattern of it, the reserves, the income part, the expense part, everything has to be highlighted in a very transparent manner in that stage. And once that is done, things get easier.
But basically, company should be very clear about the income, expense, debtor, creditors, litigations, and all that, so that can be conveyed to the court also. Yeah.
And in this scenario, the communication and the correspondence between the appointed advocate and the company is of prime importance, because all the communications, all the information, all the data has to be provided to the counsel who is going to appear before the court, so that, and see, this is a very small margin of error there in the court. I cannot, in the time frame provided to me in the open court, I cannot take that chance of having another go at it, because we already get a date after a month's time. Now if I even don't be well equipped with or well prepared with that information, I skip another month of the whole process. So these are very crucial points to be taken care by the company and the council, that they need to be end to end prepared with all the information, or all the anticipated information that the court may ask you with. So this is one of the most, advisory points from my side for all the professionals there, that who are even there. I would rather suggest that you have a very point-to-point contact with the client at this point in stage.
Another thing is that NCLT, you're not going to get your time. You have to work with their time.
Correct.
In fact, in the responses that has been, given to the authorities, we have to be very clear in drafting and very crisp. वो अर्थ का अनर्थ जैसा है. If you are not clear in the responses you have shared, it might
Correct.
go into some other trouble.
Correct. So there is one request that they missed stage 4. So I'm just going to stage 4. Now can I proceed? I believe.
Yeah.
Neela Kandan, yes, thank you. So coming to stage 6, year after the admission has been done, now this is the stage where all your printing stationery cost is incurred. Now here what you need to do is you need to, after the directions from the NCLT are received, the order is received, you need to arrange certain documents and information from the company's point of view, and then you need to serve it to all the sectoral regulators. Now that can be ROC, RD, official liquidator, income tax. If it is a listed entity, it will be BSC, NSC, SEBI. If it's a NBFC, it will be RBI. If it's an insurance, then it will be IRDI involved. So all of these entities need to be served with the petition copies, with the NCLT order, and also the notice of the shareholders and the creditors that that you are conducting a meeting or whatever. And in that specific notice, there also is a part where you inform that if you have any objections pertaining to the whole transaction, you can object to it within 30 days. And if you've not objected to within 30 days, it will be deemed approval from your side. Then there will be a filing of affidavit of service. So now what happens is, I'll just briefly explain the whole process here so that all of my viewers know as to what the process is. So once the NCLT order is filed, you need to serve it to as sectoral authorities that we have discussed, then to the shareholders, creditors, and once that is done, the public advertisement will be in place. Once all of these compliances are done, there is an affidavit to be filed by the council stating that all of these requirements of the compliances of the order have been complied with, and also notifying the NCLT that on this date the meeting of the shareholders or creditors has been conducted or has been scheduled with. Then 7 days prior to the meeting, this needs to be filed. Then on the date of the meeting, the scrutinizer will come, the chairman will come, they will conduct the meeting, the whole secretarial part of it comes into play. Once that is done, then within the next 7 days, you need to file another affidavit taking on record the chairman's affidavit, the scrutinizer's report, the compliance is taken care of, and everything will be filed after 7 days of the meeting, informing the court that the meeting is conducted in due compliance to the NCLT directives.
The public advertisement is also required to be approved by the NCLT people?
No. So the public advertisement is the notice is sent by the company itself, but in which newspaper will it come will be a directive from the NCLT. Now, generally what happens is that, now I'll tell you what happens during the order passing. So what happens is that once the application has been heard at the application stage, what we as advocates or counsels do is we provide them a minutes of the hearing. Minutes of the hearing is basically the order drafted by us, and in the open court we discuss the order. We state that, sir, this is the order, this is the details of the order, and if they are okay with the order, they will then reserve it and then pronounce it on a later date. So minutes of the order that we provide to the court is basically the order only, the draft order that we provided to them, and if they find in place, they reserve it and then pronounce it on a later date. Now in that date, in that minutes of the hearing itself, what we do is we provide the newspapers that we are intending to file it. Now let's suppose I take an English newspaper as business standard, and for a Mumbai company, let's suppose Nav Shakti is for the regional newspaper in Marathi. So there, I only suggest that I am going to publicize this notice in this newspaper, and then NCLT, if finds okay, they will approve it or not. So this is basically the whole process that follows after the application has been filed. Once everything, the affidavits are filed, then there is a petition drafted by the scheme. Now let's suppose in the meeting of the shareholders and the creditors, there are certain changes made in the scheme of merger. So that is then included in the meeting, and that has been approved by the shareholders and the creditors, and that amended scheme is then presented to the NCLT through that petition. That see, we conducted the meeting. Now this is the amended scheme as per the approval that we mandated, and the affidavits are in due place. Now we have come to you for the approval of scheme. Now at this stage, what the NCLT seeks is, so this is called a second motion petition, and this is a petition stage. Now at this stage, NCLT does not get into the inquiry mode. Rather, now it waits for the sectoral authorities to file their reports. In this stage, NCLT waits for the ROC, RD, and OL's report. Now, ROC, RD, and OL is the official liquidator. Official liquidator because there is an entity that has been dissolved. The transferor company is going to be dissolved, and that is why the OL's report is in place. And the income tax or any other sectoral authorities that are involved. So at this stage, the admission is very easy, and the NCLT admits the petition and then directs the ROC, RD, and OL to file their respective reports, so that if they have any observations, they can come to the NCLT, make their representations, and then proceed ahead.
I think there is a question from Vignesh asking whether the company has to inform the scheme to government authority like GST, income tax, ESI, EPFO.
Yes.
NOC
yes.
to be taken even if there is no pending litigation. So, Vignesh, irrespective of any litigation is there or not, the authorities mentioned by Dweep in the second bullet, the notice has to be served for the purpose of taking their objections.
Correct.
Or the comments, irrespective of any litigation, and respectively by each company in the respective state. When it comes to authorities like ESI, EPFO, City Commissioner, etc., it will be more of an information to them once the order is received. So it will be an intimation to them that the scheme of merger had happened and the order is received.
Now,
Correct me if
coming
I'm
to
wrong.
the part from NOC part, I'll take that. So, see, generally income tax, GST do not provide an NOC expressly. You have to serve them. That is a mandatory thing. That will be an NCLT directive in itself. But what we've seen is GST, income tax, or ESI, EPFO, and ESI, EPFO, they are not served directly. It is only the GST, income tax, and if required, the any other sectoral authorities that are applicable to that company, that will be served. But no express NOCs provided them. What they generally do is income tax, if they have any representations, they appear before the NCLT, they seek time to file their reports, and then they can move ahead. Or if that is not the case, if they do not appear, that means that there is a deemed approval in that scenario.
There are no issue with the income tax. By and large, generally they do not appear, and it is taken that it is actually approved. As you rightly say, deemed approval is taken. Yeah.
But there is Mr. Basant Kumar Mehta asking that how much time the NCLT takes to approve amalgamation and merger application. There should be time limit of approval or otherwise. I think this is a very frustrated viewer who has witnessed the NCLT's delay proceedings, and that is why this question has come in. And
if you are lucky, you may get your approval within 1 year. If you are not lucky, it may take years together. It may go even for 4.5, 5 years also.
By the tone of this question, I can understand that he has been frustrated by the NCLT's time taken for that approval, and I'm very sure that is the case. And if not, see, otherwise, now if everything is in place, now let's suppose the ROC RD report is, not taken in any observations, not major observations are being taken by the ROC RD, and your documents are in place, the company is in clean hands. So, what I generally keep a buffer is of 6 to 9 months or 9 to 12 months. I do not get my clients expectations high by telling them कि नहीं नहीं sir, ये तो आपका 6 महीने में हो जाएगा.
When
And
we
no
actually start,
matter
when
where,
we started the merger of the toll companies, in fact, everybody thought it will get over within 1 year or maximum 1.5 years. But ultimately, the way we experience the various sectoral approval, the litigation, the issues and other things and all those things, ultimately
Also-
we got the approval almost after 4.5 years.
also sir, I mean, Mr. Basant, what you can do at your end to speed up the process, or what you can advise your advocate on that part is that he needs to take care of the correspondence with those sectoral authorities very seriously. And if they are satisfied, that means the report will be in place within the time. And with regards to the NCLT litigation part of it, it is very, it is a very highly likely chance that they can proceed with whatever the information that you provided with. Now it totally depends as to what the NCLT asks those questions, or what are they seeking through that work, through those questions. But 6 to 9 months is a good time. If a merger is completed within 6 to 9 months, that means it has been handled.
You're lucky. You're lucky.
It
I
is
would
a
say
very
that.
lucky stance and a very lucky position to be in. But generally, 9 to 12 months is the time that I generally, advise my client.
People who are handling, they will know how difficult to get the NOC and other thing and all issued for the ROC and the RD, how much a repeated follow-up is required to be done, number of visits to be take, that people will know who are actually handling it. It is not that easy. It is not happening automatically.
Correct.
Yeah.
Correct. So this I'll just proceed with. Now, this, as I discussed, that the filing of petition, the second motion. So this is basically how what all are the ingredients of the petition and what is forming part of that petition in time. Hearing of the petition. So now I come to the sectoral approvals. That is the major hurdle that many of the companies face with. So general observations that we have witnessed in the recent times is with regards to the Ben2 form filing, the beneficiary form filing, that is a standard observation from the ROC RD's office. Then if there are any appointments to be made to the CS office or to the the director's office that has been vacant for a long time, then there will be certain questions asked with regards to the reserve treatment of the in the financials. Then there will be uh, questions pertaining to the form filings that have been taken, the past 3 form filings, then many of the allotment filings that has been done, and they will seek more information on so basically what happens is whenever a service to that petition has been made to the sectoral authorities, the ROC RDOL gives you a list of checklists, a list of documents that are required by them. Now that list involves financials of the company, any specific documents that they require, the form filing that they have done in the past year, the explanations and answers to if there are any queries that they have from the whole entity perspective. So all of those list of documents specifically mentioned by the sectoral authorities as to what they need an answer with. Also, to add to the OL office, NCLT also has a practice to appoint a independent CA to help the official liquidator. Now that independent CA is someone who has been appointed by NCLT to help the OL office. Now, when I say help the OL office, is basically to prepare the report on those companies. Now, let's suppose there is only one entity merging into the other. So this is a very simple transaction, a very vanilla transaction wherein, the OL can handle this at its end. But now let's suppose there are n number of entities, 8 or 10 entities involved, wherein the report to be made by the OL is of a huge in volume. And that scenarios, a CA is appointed by the NCLT panel to help the OL to make its report. Now, in this scenario, the OL office or the CA's office will give you a list of documents that are required from from the entities to conclude the report. And in that process, now see, when it comes to the timeline, how fast and how effectively can you give those required information to the entities, to the authorities, is of prime importance. You need to be very clear in your head and clear in your justifications that are sought out from you with regards to those transactions. And if there are any compliance to be made in response to the sectoral authorities, that needs to be taken care of in a very efficient manner, so that the report is in place and you make sure that there is no observations from that report. This helps you out in the process of litigation, wherein when the sectoral authorities appear before the NCLT, that is, if there is an RD's representation before the NCLT, then in that scenario, when he comes to you, you should be prepared in a way that there are no major observations coming from those. See, there can be minor observations like bend to filing, or if there is any compliance issues, or let's suppose the minor observations from the ROC RD's office is basically that you will comply with those accounting standards. You will comply with the provisional provisions that have been given with regards to the amalgamation and everything. So these are basically undertakings that the company needs to provide. So these observations are not of problems to the litigation process, but any compliance issues, any non-compliance is taken ahead, that needs to be corrected within time, or you need to give an undertaking or an affidavit to the ROC RD office or the OL that the same will be carried out by the new entity in due course. And to that effect, we are also providing you an undertaking or an affidavit to that instance. So this helps out your case in a very big way. So what happens during this hearing of the petition is that once the petition is admitted at this stage, there will be a date for final hearing provided to you by the NCLT. Now, let's suppose I am in September month that I get this admission of the petition. So the NCLT is going to give me next 3 months, or let's suppose a date 1 month or 2 months after the petition, after this hearing, so that in that meantime you can have a newspaper advertisement in place giving the details of the hearing, that this hearing is to be scheduled on this date as per the NCLT directives. This hearing is scheduled for a final hearing on X date. And before that, if anybody of the stakeholders have any observations, have any comments or any objections to it, you can kindly place it on record before the NCLT or to the advocate's office. Now, when between this time, you need to get the reports clean. I mean, you have to get a clean report from ROC, RD, and the OL office, so that when they come to the NCLT before for their representations, you can answer those things, in positive, and you can conclude the final hearing as desired. Now, what happens in the final hearing of petition is, now also, we come to the supplementary report from the RD. Now, let's suppose there is a report, you've provided with all the information, all the documents that the RDOL office has provided, asked for. And based on that, a report is filed stating some minor observations or whatever. To that effect, the advocate has to respond to the advocate of the company has to respond to that report stating that, okay, if these are the observations, we reply to it in positive, okay, that we'll take this undertaking, or we are going to do this compliance, or whatever the observations are, we need to justify those. And that on that basis, on the basis of our reply, the ROC RD or they will file a supplementary report to it. Now a supplementary report is a response to your reply of that RD's report. And in that supplementary report, they will state that, okay, this is the, if they are satisfied with our answers, they will, make those observations that, okay, we are satisfied with the answers. But in the end, they will keep on the discretion of the NCLT to accept it or not. Now, in the end, it is the final discretion of the NCLT to how do they deal with those observations. Now, at the final hearing of the petition, what happens is NCLT asks the representative of the RD, ROC, and OL to come in person or through online medium to firstly explain if there are any major observations from their side. Now, at this point in time, you have already responded to the RD's report. If there is a supplementary report and if there are any observations in that place, you answer or you justify it to the NCLT, and if NCLT finds it in order and to their satisfaction, they will proceed ahead and they will pass the final order. But if not satisfied, then they may reject your application as well. So now I had one of the questions that I read here was that are there any instances where NCLT has rejected the application or the petition of merger? So yes, there have been many instances of that wherein NCLT has rejected on the basis that based on the ROC RD report that this transaction is somewhat fishy, somewhat not in the correct or the legal moral value of it is very detrimental to the stakeholders. So there are n number of reasons as to why the application can be rejected with based on the ROC RD's report, or there are any operation mismanagement done on that basis, or if there are any anything that they feel is requires an investigation, or the proceedings that have been carried out in the process is only for tax evasion purposes or of that sort. So all that has to be listed down, and then NCLT concerns a view that, okay, if these are the observations from their side, I would like to reject the application. So that is where then the process is totally different. You go to the NCLAT, you go to the higher appellate authority, so to reverse those decisions and consider those appeals in that source.
There's a question has actually come once the application is filed with the NCLT. Either transferee is allowed or any corporate events such as increase of the capital,
yes, you can
buyback of the share, and
do.
Again shifting of the register office allowed. Yeah, everything can be done. Business can be as usual, but only thing is whatever the changes are taking place, you have to keep intimating the NCLT from time to time as and when the changes take place. That is one requirement. And second thing is when you are talking about the register office change, that is going to be a hurdle, because if you are filing an application from the two different NCLT, how can you shift the register office at that time unless the matter gets over? Your view, Deep?
Yes. So basically, all these corporate actions can be taken in place. Only thing that when it comes to the second motion, so now this can be two forms. Now, let's suppose you've done this corporate action at the time of application filing, then that can be recorded in the application and then done with it. Or after the application has been filed, then at that stage, when you inform the petition, inform the NCLT at the second motion, at that point in time, you need to update that in the petition that these are the corporate actions taking place, so that the NCLT is informed. Now, I wouldn't suggest this to be done at the time of final hearing. Now, let's suppose there is a final hearing on X date, and you are considering doing it just 10 days or a month before this final order is coming. I would rather suggest you not do it at that point in time, because what happens is when your order is then passed, you have to file it with the ROC. Now, when you file this with the ROC, at that point they will again have this check done. Acha, ye aapka register office change ho gaya. So at that point in time, there may be a scenario wherein the sectoral authorities come up with a unreasonable observation that अच्छा ये आपने कर लिया नहीं तो फिर ये स्कीम मतलब सी वो स्कीम वैलिड नहीं है या फिर आप ये अमेंड करके आओ. So all that we have seen. So rather what I suggest is you do it well before the final order is to be pronounced, so that you do not have to answer, or you do not have to, you know, give them more justifications or more answers to the sectoral authorities for your approval. So I would suggest you do it before the petition has been filed. अगर petition file हो गया, आपकी final hearing का date आ गया है, I would suggest you don't do this corporate action till those final order is disposed of with. And I also had one of the question that I skipped the stage 7. So stage 7 was basically petition filing, and I discussed this previously as to what are the ingredients of it and what does it basically form of. So if that is okay, I can proceed with Ruchi.
Yeah.
These are basically the recent, observations that have come in place. And this is basically the representation by the authorities to the NCLT, the whole structure as to how does it finally work out. Then this is the after approval scheme. Now that can be the application of the CTC to be filed with upon the pronouncement of the order. Then payment of cost to RDOL through Bharat Kosh portal online. Then transfer of company should not have any pending. Yeah, this is something that that needs to be taken care of after the approval is done. Then form filing, INC 28. Then the stamp duty adjudication. The stamp duty adjudication is another task altogether. Nowadays, many of the corporates are facing challenges that stamp duty adjudication has been delayed by a year or more, and everything has been complied to with, but still the stamp duty adjudication is yet to be passed with. So these are main challenges that they are coming up with, but I feel this can only be solved through correspondence and coordination with the authorities there. So this is basically the whole idea and the whole practical aspect of it. Now I have many more things to say, but now we've already come and we've touched 1 p.m. right now, and in case at this stage we can take up certain questions that that are already there in the chat box. So Dipti madam, if we can approve, if we can take up those questions.
Yeah, Mr. Bala, take it.
Yeah. I'll start from the very beginning only.
I think many we have answered.
Yeah, that is what I'm looking at. Whatever the questions are answered,
Okay,
I don't want to.
I'll just take one question that has been latest there, which is relevant to the last slide also. So once the order is issued by the NCLT, if a company wants to rectify the order, then what will be the procedure? So if you want to only rectify the order, then there is an application to be filed by the company seeking minor rectification with regards to any grammatical errors, or if there is any issues with the order but not pertinently affecting the transaction. Now let's suppose you want to say that you want to rectify the scheme, then there is a separate amendment scheme to be filed. But if you only want to rectify the order, there is a provision given under the NCLT rules to rectify the order, wherein there is a specific application given, so you can file that and then get the order rectified.
What are the practical scenarios where the NCLT had rejected the application? Can you throw some light on this?
I think you have talked that, right?
Yeah, you have talked that.
Yes, I did that.
Yeah. For calculating the goodwill and the capital reserve, do we need to transfer asset liability by transfer of the company as on the appointed date or on the NCLT order, which could be different financial year?
For calculating goodwill capital, do we need to transfer asset to as an appointed date or data transfer? So this is a very, very accounting perspective of it, wherein when do we need to do that? See, now I cannot answer with an accounting expert with that part, because I do not have that expertise. But I think there is a provisional mentioned wherein you need to transfer it as on a date of appointed date and not by the NCLT.
Okay.
In case of litigation, there is no risk to transfer a company. All litigations will get transferred to.
No, that we talked about the transfer
Yes.
of the litigation. We talked about it actually. That we answered also. And what will happen when the income tax notice is under challenging before the High Court?
That can also be taken care of by the transferee company, unless there is any material observations from the High Court and there is a specific stay order from the High Court stating that until this is disposed, there is no new corporate action to be undertaken by the transferor entity. So if there is any specific stay by the High Court for this specific entity to not do any corporate actions, you can proceed with it.
Somebody has actually shared there. If there is a lacuna in the statutory authority, I think then Article 227 is the best option.
Okay. In case transfer company doesn't have any asset and there is only cash, will there be any stamp duty? The stamp duty is based on the consideration given. So whatever be the consideration price will be then automatically adjudicated for stamp duty.
Yeah, notice of admission that you talked about it. Printing of legal paper, that also you talked about it. Stamp duty also you talked about it. Valuation report also I think you address actually. Then whenever the financial statement with the NCLT, we will
is
be audited.
Valuation report required for reduction of share capital? So this I believe we can take up in
reduction.
Yes, reduction of share capital.
Yeah. For creditors,
whenever
also
we file financial statements with the NCLT, we will audited or provisional is audited more than 6 months. In such a case, only financial with schedules without all notes is it permitted? No. You need to provide it with the whole schedules and everything. For creditors, one should speak to large. This is also, we've done that.
Yeah. On creditor, one should speak the large that you talked about it. Some cases, some of the creditors paid up, that also you talked about the elaborately you gave
so
that.
Rajiv Bhatia has this. ICSI can sensitize to the government for lapses in NCLT copying PM. So now this is also another frustrated viewer that has faced certain delays from the NCLT, I believe.
Okay, can we explain from any practical charter? That also you talked about chart account strategy auditor, you talked about it. What are the regulatory approval for a cross-border acquisition? The occurrence of the Indian company and the target company is the foreign company.
So cross-border acquisition is basically you're talking about a cross-border merger. Here, see from the acquisition point of view, when you talk about a target company, it is totally coming under a different purview. But if there's a cross-border merger happening, then there is an RBI, the FACRA provision, and everything of that provision that need to take care of. Nothing, with regards to anything that requires any intervention from the international authorities of that sort, but only FEMA regulations have to be complied with. Any observations from the RBI have to be taken care of, and the approval from the RBI is required.
The scheme information to the authorities, you already spoke about it.
And I have Maulik Kesaria's question: brown files for submission at NCLT, elaborate please. So basically, this is a very procedural requirement. There are the filings made to the NCLT are specific to files. There are this I'm talking with regards to NCLT Mumbai specifically. That there, what happens is there is a brown file which has all the stitching done. Is very specific to the NCLT's requirement. So that is where this comes from. Entire petition requires notary. So
earlier we used to have in High Court what you call red book.
Yes,
it is
sir.
Similar to that.
Yes, absolutely, sir, absolutely. Okay. See, Chandrasekhar, entire merger petition requires notary. Yes.
Yes, that is there.
Multiple sign the application. Let's say 1,000 pages by first director and no. So basically, you even though you have them authorized in the board and the board resolution, but now it doesn't make sense. No, okay, even though both the directors have been authorized, but then I would suggest rather you don't take the tricks on and have it signed by only one representative.
Correct.
Compounding application is CP or CA. It is CP.
The whole NCLT is actually a data house now. All the RPs are brokers.
Another frustrated viewer.
Okay. Then
Can this be highlighted to the PM and legal ministry that these are going?
These are all, we cannot answer these questions. We proceed. How much time NCLT has taken, that I think you answered. Once a petition to either that answer, that also we talked about. Once the order issued by the NCLT,
We have done
company
that.
wants to, yeah, we have done that.
How shall be the ROC filing be done for both the companies between the appointed date and the date of the order? Should be the ROC filing be done? ROC filing as in, are you talking about the financials, Mr. Ulas?
Or I think it's a normal filing, whatever action is taken, or both the company will run the business as they want, and also there will be events, and you file forms like as it is, independently. Both the company will file independently as if no merger has taken place.
Correct. That is right. Each
And,
company has to file that. Yeah.
Demerger scheme approved by the RD on October 2024. Now the management has decided to change the appointed date. So jurisdiction will lie with RD, man. But RD approved demerger scheme, I don't know. But it'll be, if it has been passed by the RD, then it will
Yeah,
be.
who has authorized that, the same authority it will go.
Company had investment.
Only, yeah.
And also, Mr. Dushant, thank you for the comment. Company had only equity investment in another company worth rupees 100 crores. Now board decided to demerge the investment part to another entity. Will NCLT approve the scheme of demerger definition or undertaking? So this is a legal opinion that you sort out. This will require a detailed analysis.
Yeah, unless until you give this thing. Yeah.
What is the role of Competition Commission of India? So I'll take up this. Yeah. So basically, if there are any two major players of an industry who are merging at that point in time, based on the eligible criteria of what has been defined under the Competition Commission, that will be analyzed, and if that has been affected in that transaction, if that falls under that definition of under the Competition Commission, then that sufficient justification or answer by the merging entities have to be given to the Competition Commission of India. So basically, the role of Competition Commission is that to avoid any monopoly situation in an industry, wherein it is so difficult for another entrant in the market that to develop a market in that industry specific areas.
You mentioned stamp duty. You mentioned stamp duty will pay the consideration even in case of 100% subsidiary company. It will be, even in 100% subsidiary company, it will be the same.
No, there will be no stamp duty.
Yeah, because between the parent company, subsidiary company, they won't. It will be only for the other thing.
Yeah, there is no consideration involved at all.
Yeah,
that will be totally accepted. Correct.
Any specific reason for the different procedure between the different NCLTs? That we cannot answer because everybody, they got their own rules.
Basically, majorly, Mr. Subbalakshmi, they follow same criteria. Only procedural requirements with regards to, let's suppose, the filing of part of it, or that differs. There is no major difference in procedural handling.
In a particular matter, referred the jurisdiction of NCLT has recommended to the president to form a larger bench to decide the matter. This is only 10 months, but nothing has happened yet. What should be the procedural early disposal of the matter?
Kindly mention it before the NCLT bench again, and you can address this issues that it has been more than 10 months, and you'll have to continuously file it. Mention it before the open court, or rather file an application to move the process ahead very quickly.
Post order, whether it will be
post the order, will the consolidated filing be required again to be done from the appointed date to the order? So basically, as I told you, this is a very accounting perspective of it, but what I've seen is they generally keep the provisional accounts ready for filing from that date. So that is a very accounts perspective question that I may not be in a position, but what I am aware of is the provisional part of it.
In case of the creditors meeting, ordered by the NCLT, and the absence of the NOC, whether the scrutinizer will be appointed by the NCLT or the company itself.
You can suggest the name of the scrutinizer in the minutes of the hearing, but if the NCLT is totally upon its own discretion, if they are okay to approve it, they will approve it, or they will appoint it through their own panel.
What are the costs of the regional director and the official liquidator? Please specify the basis.
What are the costs to? So this is if any required, the compliance part. Nothing in specific.
The transfer company needs to get a financial audited, but then up to the date of the merger, order of the date on which INC 28 filed.
Yes, you need to have it from the last financial year, and if there is any, till the date of the order is filed with the ROC, that till that date. Yes.
Scheme amendment, you spoke about it actually, there is no problem. And asset and bank balance, that also you talked about it. How do the merger application go? Refer to the competition commission also you talked about it. Whether segment reporting record in case of the demerger of the purpose for the capital gain exemption.
Whether
segment reporting record in case of the demerger for the purpose of capital gain exemption.
Segment reporting, I'm not aware of.
Segment reporting is totally different. If you're having a two different division, etc., that is altogether the different thing as per the accounting standards.
Mr. Millen has this question: can the scheme be amended in case there is a type of error related to the share capital?
Yeah, that also you answered, I think.
Okay.
Yeah, that's all. I think we are done with the questions, whatever is there. So
there is time gap between appointment date and execution date is more than 12 months. What to do then, or if it can cut across more than one financial year? So this is a general scenario. In that case, as I told you that the appointment date and the execution date is more than 12 months, then you need to just justify it to the NCLT as to why you need a appointed date more than a year.
Yeah, you actually elaborated initially, and you also set up on the importance of why having it within a year or something like that. That's what you actually said, actually. Yeah. If NCLT appointed, yeah, that is what. Yeah, I think we are done with that. I think you can close the presentation here.
Great.
Dipti, it's already 1:15. So, if should we ask the people to raise their hands and answer their questions if time is there, or we'll call it a day?
I think we'll call it a day because all questions we almost answers.
Okay. Okay.
Or still, if anyone has, we'll take one or two.
Yeah.
We'll
Anybody? Yeah. Anybody
because
has got any question?
Somebody already raised a hand, but they never know. Yeah, Mr. Rajeshri. Rajeshri Bhaumik, you can.
Rajeshri, you are there. You can unmute the mic. You can talk. There's one more I can see, Kanchan. There's one more here. Girija. Yeah, all of you, any one of you can unmute the mic and talk.
Yes, Rajeshri, you can unmute and talk.
Deep, I think you can stop sharing the screen.
Yeah.
Hello, am I audible?
Yeah.
Yeah, very much.
Yeah, thank you, sir. This is Kanchan. I have raised a query regarding to the stamp duty. It has been said that since between the 100% subsidiary, there is no consideration on this part. So in case that transfer company doesn't have any asset and it has only cash and bank balance, whether there will be any stamp duty payable to on it in such kind of transaction?
That we have answered.
Okay.
That. So there will be no stamp duty.
No stamp duty.
Basically, wholly owned and those holding company don't have this stamp duty implication.
Okay. Thank you. Thank you so much.
Yes, any one of you, Rajeshri or Girija?
Sir,
Hello? 1 minute. Who's that?
Sir,
Rajeshri.
Yes, sir. Then my question is, if the NCLT is causing unnecessary delay to adjudicate or to give the opinion, can we approach the Honorable High Court under Article 226 and 227 praying for speedy disposal?
So you can do that, but I would rather not, advise you on that, because see what happens is once that is done, there is another litigation hurdle that you create parallelly at the High Court. So rather the efforts that you make in the High Court, you rather make those efforts in the NCLT itself to seek that disposal. Because see, any additional High Court intervention, that is a parallel litigation hurdle that you create. Rather, I would suggest you take those efforts and time and money in that NCLT litigation itself.
Okay, but I can.
You can obviously.
Okay, thank you, sir.
Yeah, you can, but the only thing is it's all going to be, futile your time and energy and other things. That's what it will happen. That's the whole idea.
Okay, Kanchan, thank you, Mr.
Yeah.
Iqbal.
Like Girija.
Kanchan already spoke. I think Girija.
Yeah. Good
Yeah.
afternoon, ma'am. I'm Girija here. Ma'am, this is regarding the transparent company. Now, appointed date of the merger is decided as 31st December 2024. So the transparent company has to close its financial as on 31st March 2025 and do the needful filing of the financials.
Yes, even though your scheme is filed, it is not approved. So you both company are independent working and you have to keep on complying the program.
Yeah. So even
Yeah.
after the finalization of the merger, till the date of the merger, whatever is the effective date, till that date, the transparent company will after that also draw its balance sheet and do the needful.
Yeah. Till the approval is happen, all the compliances what are required, it will be done
Okay.
year after year. That has to be done. Yeah.
Okay. Thank you, sir.
Only thing is, when the scheme is approved, you have to consolidate everything year after year, and you have to bring to the thing. That is another big effort which is going to take place after the merger. Yeah.
There was a question, Dweep, that whether that required that consolidation after effective date, again,
Yes,
all the
yes.
accounts will be consolidated and from appointed date, all that will be fine.
Thank
Yeah.
you.
Okay.
Yeah.
Anything
That is
else?
all. Yeah, that is all I think so far. Everybody who was raised, we already answered the query. I think we can close the session.
Yeah. Thanks, everyone. Thanks, Mukti, for your time and your inputs. Thanks a lot. Thanks, Dweep, for wonderful presentation and your inputs. Thanks, everyone. See you
Thank you
next
so much. Thank you so much for having me.
Dave, my sincere thanks to you for an excellent sharing of the knowledge and the practical use, what actually happens, the NCLT, etc. You have virtually taken us through the NCLT proceeding itself. That's what I would say.
Thank you so much.
Thanks a lot.
Thank you so much.
Yeah.
See you
Thank you,
all
Mukti.
next week for reduction and process matter. Thank you.
Thank you.
Thank you so much. Thanks a lot.
Have a good weekend.
Thank you.
Yes.
Bye.
Thank you.